because I was there, and I didn't. If I'd known 30 years ago that the stocks of rule of law were going to soar the way they have, I would have put any money I could find into it instead of just talk. But I didn't know I was talking up a gold mine, which it has now become. Given that it is such a central cliche of our time, it's also become attached to three supplementary cliches, what you might call meta-cliches, cliches about the first cliche. Every article you read anywhere will tell you, first of all, the term is everywhere. It's ubiquitous. Secondly, they'll say, and it's promiscuous. It's been courted by suitors for all sorts of things, and it says yes every time. And thirdly, they'll say, and I'm sure this phrase will appear and reappear, it's so essentially contested, who on earth could tell you what it means? Now that is a position of great lustre, but it also makes the concept, which apparently is so important, very difficult to deal with, and how should you deal with it? One way perhaps, which has been tried, and I think is fruitless, is to try to track down the meanings of the phrase, the words in the phrase. Joseph Raz did a bit of that. I think, along with some other people, that that's a fruitless way to go, both for two reasons. One is, there are many phrases which converge on similar problematics, on similar problems, on similar hoped-for solutions. We can talk, Aristotle said, but I don't know it in Greek, of the rule of the law and not of any individual. James Harrington in the 17th century talked about the empire of laws and not of men. Other phrases have been used. There is a sense that there are some recurring issues, problems, concerns, also disputes that are constellations around these phrases, and so you can be talking about the same things without using the same words. Not to mention, but of course, as Sana mentioned, different traditions use different phrases. The English tradition that says nothing about the state, the continental traditions say nothing about rule, but that's not the only difference between them or within. So this and the other point is, you can have the phrase, as is now, as I've mentioned, ubiquitous, and still have no idea what people are talking about, because people are talking about so many different things. So tracking the phrase is not going to get you anywhere good. Another possibility, which is actually has been defended rather implausibly, it seems to me, by a very clever guy in the World Bank. So look, there's all this lament about what the rule of law means. This is Deval Desai from the World Bank, also from LSE. There's so much talk about no one knowing. We know what it means. We just look at what the hiring agencies of international development agencies like the World Bank look for. From there we can find what the World Bank is. There's a kind of arrogance and presumptuousness in this, as though this phrase and these range of concerns, which are millennia old, were just waiting to be given substance when the World Bank got its act together at last. It seems to be implausible, and also, to use a technical term, stupid, because we aren't that smart. These concerns have been around, or many concerns, with people who use phrases like this, have been around for a very long time. So my proposal is that we seek to pursue, this is a phrase of Michael Oakeshott's, pursue the intimations of traditions which have been concerned with some common range of problems, which have very often been referred to in phrases like the rule of law. What problems did people think it was important to find solutions to? My suggestion, now it may look as though I'm, to use the English phrase, I don't know it in Dutch because I know nothing of that, it may look as though I'm cherry picking, low-hanging fruit, but of course if cherries are tasty, that's what you do for people. And so that is what I'm doing. It's not fine intellectual history which I'm going to offer you, but a certain rumination, an attempt to pursue intimations of certain concerns which have occurred, which have been debated, which have had choppy paths, which don't have a single linear trajectory, as is mentioned, I think, implausibly in referring to the conference. I don't believe that people who have thought seriously about the rule of law see it as being on a kind of ever upwards trajectory of success. It's certainly not been my experience, and that the experience it seems to me to work. Is dangerous, frequently malevolent, and something to be always worried about. Now, I've like so many people, said for a very long time that the notion of arbitrariness is notoriously under-theorised. And I've always felt a bit weak because having said that, I go on and say nothing about the theorising of it. So now I'm going to chance my arm, not in some conceptually pure way, but again gesturing to things that you can pick up from tradition of such concern. Is this going too far? You don't know this, but this paper is 25,000 words. You've had 10 of them. So, if it's okay, I'll just keep going. I want to suggest that in traditions of thinking about arbitrariness, often with that word in various different languages, central in the common law tradition, but also in many languages, words such as arbitrariness occur. There have been three sorts of concerns, maybe more, but these ones occur to me. Not always held by the same people. Some people have settled on one or other. It seems to me that arbitrariness in all of these three forms is an unfortunate thing, and we should be worried about it. Or better than that, we should seek to do something about it. First sort of arbitrariness, and I imagine the first sort chronologically too, is where power wielders are uncontrolled, subject to no control. They can do what they like. They exercise their arbitrium. There's a lovely phrase in an Indian case where the state natural resources ministers told that he can't take resources, that these resources, just because he chooses to, these resources, national resources, should not be at the sweet whim or will of public officials. Sweet whim or will. So that's one sense of arbitrary power. A person can just arbitrarily do what they like. A second sense, that is the sense that the common law tradition until the 18th century had at its centre. The king is under the law. The law is the bridle of the king. The law must, in the words of the 13th century English compiler of laws, Bracton, must temper the power of the king. From the 18th century in Britain and from the late 18th century in the Reichstag tradition, another sense of arbitrariness became prominent, and that is where power wielders act in ways that the subjects or objects of the power could not know, predict, understand when they were making the decisions. And so you have the laundry lists from Fuller and Raz and many others, that the law has to be clear, non-contradictory, public, prospective, and so on and so forth. That is a coherent range of concerns. It's a different range of concerns from the first one. The common law was notoriously something that came from the immemorial past, clothed in custom. We didn't know exactly what it was. The important thing was that it controlled the power in the king. The second constellation of values has to do with clarity, understandability, etc. But there's and Fuller and Raz talk a lot about that. A third conception, it seems to me also of arbitrariness, plausibly called arbitrary power, is where the king might be controlled, the power might be understandable, but it is exercised without any opportunity given to the objects or subjects of power to enter with their voice, with their interest, with their presence, with their personality. This is a concern which Jeremy Waldron has recently raised, but it's not a recent concern. It's an old concern built into habeas corpus, to a whole range of legal procedures about evidence, about allowing people their input. It seems to me that each of these forms of exercise of power is arbitrary. Each of them is, to use an expression I'm not sure much either, is on the nose. We should worry about it. And each of them has prompted people over generations, over millennia, to think, not everybody of course, some people, kings in particular, think they're entitled to do it this way. Stalin didn't respond well to Fuller's, didn't respond at all to Fuller's concerns. Many power holders don't take into account the voice and interests of peoples. But in any of these three options, and maybe others, power exercised these ways is arbitrary and it should be concerned. And it has been a concern in long traditions of thinking about the exercise of power. Which leads me to, well, what do people think the solution is? Of course, there's been many and varied, and the more particular they are, the less well they last or travel. The way that Aristotle wanted to institutionalize restraint on possibility of arbitrariness in terms of specific institutions is not something we remember. But we do remember that he said it is better that the law should rule rather than any individual. Too much can be made of that as though it's a dichotomy, and all sorts of smart alecks will tell you, well, you need people. Well, he knew that. Aristotle was not a fellow. He knew that the rule of law did not replace the rule of people. My sense is, my hope is, that what you get here is a kind of seminal thought about the importance of institutionalizing power. Why? Because, and this was strong among the Greeks, not just philosophers, but dramatists, etc., that temperance is not just a personal virtue, but an institutional virtue. That moderating power, that hubris is something to worry about. In fact, the Greeks had laws against hubris. That these are concerns which we should be thinking about ways of institutionalizing responses to. I don't think that the particular ways people put on last very long at all, but the concern is a deep one. In the paper I go on at the inordinate length, trying to document this concern, not in some linear way that this went from Aristotle, but it crops up again. It crops up in Marsilius, it crops up more than crops up. It frames the whole discussion in Montesquieu and the Spirit of the Laws, which is all about not who rules, but how power is exercised. It is always better that power be moderated. That doesn't happen by accident. It's a very hard thing. It doesn't happen by chance. It's not easy to do. There are more despots than there are moderate. But even though despotism is horrible and moderate power is wonderful, moderate power is a difficult thing to engineer. And it takes thought, and it takes reflection, and it particularly takes reflection on the laws. Then you have long English tradition. Of course, last year was the encomium to Magna Carta, of which the English make much too much. But it's not that there was nothing there. There was something there. I can talk, if you want, more about this, where I'm just pinpointing some names in discussion, but I don't have time now. It gets caught up again in the 17th century in England, mythologized, but not out of nothing, in the hostility of John Locke to arbitrary absolute power, in the debates between the king and parliament, between the kings and the courts, in this ideology of the restraint on even the most powerful by laws. That gets picked up by the Americans who ultimately revolt against the British for very British reasons. They believed that they were being treated arbitrarily, and the tradition they inherited said that was the wrong thing to do. The British had moved on to a more Rechtsstaat legislative power and so on, and the poor Americans say, hang on, what about us? We're British thinking. Now, it seems to me that these, and this is where I come to some sort of normative comment, that the traditions which emphasize these concerns